Hello everyone. Marriage is often seen as a union of love and commitment, but it is also a legal contract with real financial consequences, especially when it comes to property, debt, inheritance, and the division of assets when you divorce. For many South Africans, these issues become even more complex when marriages are concluded under customary law and later formalized through a civil marriage. This week, the Constitutional Court delivered a landmark judgment, making it clear that an antenuptial contract signed after the conclusion of a customary marriage cannot override the legal consequences of that customary union. Now, to unpack this and what it means, whether you're married, planning to marry, or building a life and assets with a partner, we're joined by Zola Mbatha, a fiduciary and family dispute attorney, to help us understand the law, the risks, and the steps couples should take to protect themselves properly. Zola, thank you so much for coming onto the show.
Sure, it's lovely to join you, Buti.
So in simple terms, what did the Constitutional Court decide about antenuptial contracts and customary marriages, right? And why is it such a landmark ruling?
Sure, thank you so much. It's lovely to join you, and I'm very happy we're having this discussion because it obviously impacts millions of South Africans. But you would know, before the Recognition of Customary Marriages Act in 1998 was promulgated and became an act, we as Africans knew that we do lobola this year, and then a year passes, and then we get into a civil marriage, lasio sinacon. That's what it's called, where we are going to become papered and wives that are officially married through home affairs. The Constitutional Court judgment is basically saying that is very unnecessary. The reason being, your customary marriage is recognized. Once it is recognized, you then cannot enter into a secondary marriage. The customary marriage that is recognized is automatically in community of property, unless you put in preventative measures to ensure that you're not in community of property. Prior to the customary marriage, to the recognition of customary marriage. Now, because of the practice that we have all been, entertaining of getting married a year later civilly, we were only getting into antenuptial contracts before the home affairs marriage, is what it's known, the civil marriage. The Constitutional Court is saying all of those antenuptial contracts are invalid. Basically, if you have entered into a customary marriage through lobola, the 3 requirements to recognize a customary marriage, and you did not enter into an antenuptial contract before that, you are married in community of property.
Now, that's an absolute game changer, isn't it?
Yeah, it absolutely is. I think the one thing that we need to maybe just take a step back and go into is, what are the 3 requirements for customary marriage to be recognized? The first is you have to be of legal age, so we know that that's 18. The second is you have to consent to being married customarily. How consent is interpreted through case law, if you look at the double HP and Lerato case, is when the man or his family writes the lobola letter, they're obviously consenting to taking part in this ritual. When they send that letter to the woman's family, and the woman's family looks at it, reads the dates they intend on coming on, and invites them over, that's an automatic consent of that process happening. Then when they arrive on the day that they've asked to come, and they were allowed to come on that day, they take part in these little rituals, and some of them, I'll use the Zulu culture for example, where there's a young boy child who's probably been made to climb a tree, and then there's some money you need to put on the floor for him to come down, and some money on the floor for the gate to be opened. By the time they sit down, they start talking about the actual lobola, the bride price. They've already started negotiating. And when they get food, for example, or some supplements to celebrate that day being a successful day, that is seen and interpreted as a celebration of their culture. When they finish with that process, they basically have qualified for a customary marriage. And that's made a lot of people very upset. And the reason being is our cultural leaders have not necessarily taken a forward and proactive step to come and define what our cultures are. Because again, I'll use the Zulu culture. What I've just described now is not even the full lobola process. It is ukuyocela. It is our version of engagement. And now the interpretation by courts of the Recognition of Customary Marriages Act and the validity of our customary marriages are getting us married at engagement phase. And that's what's upsetting people the most. And the only way to fix that is if the cultural leaders really do take a step forward and say to the courts, please can you give us a date to approach you so that we can define to you what are our customs. Because in its current format and using the double HP case, you are getting our people married at a phase where they're still asking. You don't even have to leave the full lobola, Buti, for your customary marriage to be recognized. The lobola itself is not even one of the 3 requirements. for customary marriage.
So
it's just a factor.
Whose responsibility is it, Zola, to carry out this engagement and carry out and give clarity? Because we know that ignorance is no excuse, obviously, in law. So, but it would seem that there potentially is a lot of ignorance.
It's not ignorance, Buti. It is the implementation of South Africa's constitution, which upholds the principle of fairness. If you think about the old show, Kwakala Nyonin, where Mandlanduna had a cultural wife at home, and then he went to Joburg. Our grandfathers, they went to Johannesburg to go work in the mines, and subsequently ended up marrying the woman in the mines with, through home affairs. And those women, when they died, when the grandfathers died, they would go back to the cultural home and claim everything because their marriage is documented. So it's not ignorance. The Constitution wants to say these cultural and customary wives have been discriminated against by virtue of the fact that a customary marriage is not registered. So we now are going to ensure that it is recognized even without registration. If you remember the 3 requirements, it's legal age, consent, and, the cultural negotiation and celebration. Nowhere is there lobola there, nowhere is there registration. But all of that will obviously be fixed by the new Marriage Act. I think, our government, as well as our legislative departments, are realizing actually the current format of the Recognition of Customary Marriages Act is a bit prejudicial. You're trying to fix an old prejudice by creating an entirely new one. Why is there a new prejudice? Because so many people paid deposits. So many people paid a little money to go lobola and change their minds, and subsequently, years later, ended up marrying someone else with that civil marriage certificate. There's 2 cases. Actually one, let me go into one that maybe will help with what I'm explaining. There's a woman, it was decided last year, June 2025. A woman lobola was paid for her 45 years ago. And then that relationship didn't work out. Her husband her husband, because that customary marriage is recognized, subsequently went and married someone else using the the Marriage Act, and got the Home Affairs marriage certificate. When he died, the woman who was lobola'd 45 years ago came, instituted a court application and said, my marriage was not divorced. And that woman is who got the estate, not the one who had the marriage certificate.
So Zola, let's unpack this a little, right? So you have an individual, for instance, who lobolas, right? So becomes customarily married to a woman.
Basically.
And then decides a few years later that he's
not working out.
It's not working out. So he leaves this woman. They carry out whatever traditional aspects to terminate.
100%.
To terminate, right?
Which is to sit down with the family and say, we no longer want to be together. Okay.
Or maybe not.
Okay,
right?
or maybe not. Just move on.
Just move on, and then he goes and he goes to court, and he has the white wedding, as we
he goes to church, and then he goes to Home Affairs and registers the white wedding with another woman.
What is the status of those 2 marriages? I mean, what does it take to terminate one?
The customary marriage.
The customary marriage, right? And number 2, if it hasn't been legally terminated, what happens to the
certificate one?
Yes.
It's invalid. It's exactly the case I just told you about, the woman who lobola was paid for 45 years ago. The customary marriage and the civil marriage have the same rights and the same powers. The only thing that's different is how you enter it. The customary marriage, generally the practice is to write a letter, a lobola letter, telling the bride's family that we're coming on such and such a day to come pay lobola, and that's what happens. That's the start of the customary marriage. And then they've already made 2 requirements, the age and the consent. Then when they arrive, they negotiate and enter into a valid customary marriage. They don't have to finish paying the lobola, and they do not have to register it at Home Affairs. But this customary marriage exists and it's valid. Now, the example you just gave is millions of South Africans. They break up, we didn't sign. So they don't bother themselves. Some even go and do the whole, let's sit the families down and tell them we are now breaking up. So they even go as far as to write affidavits. Our children have told us they are breaking up. But according to the law, the Recognition of Customary Marriages Act, that is not the way to get out of a customary marriage. You literally have to go to court and institute a divorce and get a divorce decree. And if you haven't done that, your civil marriage is invalid.
So right now, if you, from memory serves me right, if you're going to get married, right, in court, or you're going to have the white wedding, there is a check on a register to confirm that you are indeed single.
Single, yes.
Right? Is there a register for customary marriages.
That's what's causing the issue.
Exactly. And how do we work around that? I mean, let's talk about some of the biggest legal mistakes that South Africans make around marriage, especially in the absence of a certificate for customary marriages, which doesn't exist.
Yeah, right. So that's exactly what's caused this issue, the lack of registration. So the legislation Recognition of Customary Marriages Act has caused this by not enforcing registration of a customary marriage. And how the legislative department is fixing it is creating a new marriage act. It's currently called the New Marriage Bill 2023. We are in 2026, Puti. It's still a bill. It is not an act. It's still out for public opinion. It still has to go through a lot of, legal doors before it becomes an act. But that act, when it comes out, it will force everyone to register a customary marriage the same as a civil marriage. And whoever is already customarily married will have 12 months to go to Home Affairs and register it. And if they have not registered that customary marriage after 12 months, it itself is now gone. So you can enter into a new marriage very, easily after the act has been promulgated. But when is that act coming out? And that's a very important question, because that is what's going to fix what's currently happening. I mean, here's another risk that I think is very important for us to outline. If we look at what we've just discussed now, and these many millions of customary marriages that are recognized, yet people choose not to recognize them and they're moving on. Right now, as they're learning, and the Constitutional Court judgment has just told them that a customary marriage is actually a very is a very recognized marriage. If someone is broke, they can just simply go institute a divorce so that they can get the pension fund from the person they paid lobola for many years ago. That's a high risk, and it's an unnecessary and a very unfair risk, which is why the New Marriage Act needs to really hurry up very fast, so that people don't get prejudiced in this manner, because it's a very, it's a big loss that they stand to suffer.
So let's bring in polygamists into the equation, right? So we've got a number of individuals across the country that have more than one wife, that they've customarily married.
All of them, yes.
Yeah, and they've married all of them, right?
Them, yeah.
So in this instance, what happens to the legality of those subsequent marriages, right?
Sure.
So I marry woman A in 2010, 2012, 2016, 2020, and I'm on the verge of another marriage
Woman
in
5.
2026.
Sheesh, Puti, you busy?
Nice illustration there.
I know. There are people who actually roll like that. We watch them on TV.
Yeah.
So the Recognition of Customary Marriages Act does recognize polygamous marriages. What it does also recommend, and very strongly, and I'll tell you now why I'm using the word strong, is that the first wife must consent to the other woman joining her in marriage.
So
and
it's recommendation, it's not legally binding.
It is now legally binding as a result of precedent. What creates precedent is case law. Once a court has made a decision on something, everyone else has to follow suit. And the thing is, that's my biggest objection with this legislation, Recognition of Customary Marriages Act. It's so unclear. It's got ambiguous characteristics in it, and it's court that is deciding for us what our culture is, because of the lack of cultural leaders that aren't coming forward, and because of how unclear the act is. So court has to make a decision, and once a decision is made, you follow. And there's no higher court in South Africa than the Constitutional Court. It's the apex court. Therefore, all other courts must follow the fact that these antenuptial contracts are invalid. Now, with the polygamous marriage, the act specifically states you must have a discussion with the wife. Well, not in those words, and the first wife must consent to other wives joining her. And the reason for that is, again, the principle of fairness. When he marries the first wife, he builds an estate with her. By the time the second wife comes, there's already $1 million. I'm using an example. Yeah. There's already $1 million in this estate. She now is about to benefit from $1 million that another woman built with her man. So the court says the Recognition of Customary Marriages Act specifically states you cannot enter into a polygamous marriage without bringing the subsequent wives to court and have it contracted so that we can determine what regime your polygamous marriage falls under. So with the lack of that contract being approved by a court and the lack of consent by your first wife, that the rest of the wives are not recognized. When you pass away, they're just the same as girlfriends. It's just that you paid lobola for them, but the law doesn't recognize them. But that's not to say the ancestors and the cultural people from your family don't recognize them. We're talking about the law and the financial consequences of marriage. So if you want to enter into a polygamous marriage, you must take your subsequent wives to court to get the contracts of those marriages regulated and decided on by a court, and you must get at least verbal consent from your wife. But when that new Marriage Act comes, the consent has to be in writing.
Zola Mbatha, fiduciary and family dispute attorney. I appreciate your time. Thank you so much for coming on to the show. Certainly much to unpack, and it's all going to be happening as the Constitutional Court clarifies status of antenuptial contracts in customary marriages.